from Curwens Solicitors. We have offices in Royston, Hoddesdon, Enfield, and also in North Finchley. Curwens has been going for over 200 years, and I've been at Curwens for nearly 25 years. Marriage, 2 children later, and I'm still here. I started as a solicitor in the private client department, and now I am the lead there now. I'm also a member of STEP, which is a recognised group of people who practice in my area. So I'm a specialist in wills, trust, probate, powers of attorney. So today I'm going to be talking about wills and lasting powers of attorney, and possibly touch a bit on probate. Now, why do you need a will? We've got an election coming up, and we've got possibly a new government coming through. But who wants the government to determine who gets what from our estates? I don't think anybody here wants that. So if you don't have a will, the government will determine what happens to your money. And I'm sure that's not what you want. You may think, I don't need a will, everything's going to pass to my common law wife, partner. No, it won't. Everything's going to pass to my spouse. Well, it might do, but not necessarily. Under the intestacy rules, part of your estate will pass to your spouse, but it could be divided between your spouse and your children. And if you have no children and no spouse, then it could pass further afield to people you really don't want to benefit from your estate. So really, a will is your opportunity to state what you want to happen to your affairs. And a will, let's talk a little about a will. As I said, you can state exactly what you want to have to happen to your money. You can nominate, you can give money, small gifts to your favourite charities. Age UK Barnet is a charity. You might be religious. To a friend who's actually been more like a family member than your other family members, you might want to leave a gift to. So a will gives you the opportunity to recognise people. It gives you the opportunity to nominate who you want to sort out your affairs. People think, oh well, my spouse may sort out my affairs, or my children might sort out my affairs. Do all the children always get on? Would you think there's maybe one person who's better to sort out your affairs than others? Maybe so. In your will, you can nominate who is going to sort everything out. You can also take advantage of any inheritance tax planning. Rebecca's gone through some of these things. So a will is an opportunity to make sure you maximise the opportunities to save tax. These are some possible reasons why you should make a will. You might want to explain why you've actually excluded somebody. Very few people generally exclude people, but there may be good reasons why you do want to exclude somebody. So if you have a will, it's your opportunity to do so. You might have, you may have beneficiaries who can't manage funds themselves. If you don't have a will, they'll automatically, by law, they will be the beneficiaries of that sum of money, and it could be a considerable amount. If you have a will, you can put in what's called a trust, and you can nominate people who will look after that money for that person. It might be a case that they are receiving support from the state. By giving them money directly, they may lose that support they're entitled to. So it's sensible to consider putting a trust in your will. There may be a second family. We've got blended families, very common nowadays. You might want to ensure that your children from a previous relationship and your current partner and your children with your current partner all benefit equally. If you don't have a will, that might not happen. So that's why it's important to sit down and think about these things. A will also can reflect what you've done in the past. Rebecca talked about making gifts. You may have given a large sum of money to somebody in the past. Maybe you're thinking, maybe in my will, I've given this so much money to them already, I might give them, scale it back on what they will receive on death. And Rebecca talked about letter of wishes. Alongside the will, you explain to the trustees, explain to the family if you've made any alterations and why you have made a decision to do that. You can also provide specific guidance to the executors. There may be tricky situations your executor's going to have to deal with. A will can do that. And also, as Rebecca said, it's a good idea to get everything organised. Write a list of where all your accounts are. Also think about, so many people are online now. So who knows what passwords? I can't remember my own password. So, you know, think about if you've got lots of passwords, where do you want to keep them safely? And if someone's got to access your accounts in the future, how are they going to do that without having an idea? But don't give it away, obviously, your passwords. I'm not saying give your passwords to anyone, especially if they ring up and ask you for your password. So, points to consider. So, funeral arrangements. This can always cause a lot of issues. I've had situations when one family member wants to do this. Mum said she wanted to travel back home, back to Africa to actually, you know, be buried. No, Mum wanted to be buried with the children here. You know, someone's passed away. These things cause real angst. Some people don't want anybody to come along to their funeral, and a will is your opportunity to say, I don't want anybody there. So these sort of things, they might seem small, but they can cause a lot of stress for your, you know, for your loved ones, because they're stressed already. If they know what their wishes, your wishes are, it makes life so much easier. And especially if you have professional executors, again, it's your opportunity to tell them exactly what you want to happen, what pub you want your wake in, and what you want you know, how much you want to spend on your wake. Executors, we've talked about. Think carefully about who the executors are. Are they up to the job? Do they need support? Will they be too upset to deal with your affairs? You know, just have some consideration about those things. We've talked about legacies, leaving legacies to people you care about. And the residue. As I've said, you might want to leave everything equally to everybody, but you might consider not leaving it equally to everyone. And if you're leaving it, say, to children, and they have children, what age would you want your grandchildren to benefit? If you don't put an age down, they will benefit at 18. You might think that's too young. I mean, an 18-year-old with a few thousand, if that unfortunately happens, you might not want that to happen. You might want to extend it to 21, say, or 25. We talked about wills and maybe second marriages. You might want to ensure that your spouse can stay in the home for as long as they want, to the end of their life. But ultimately, you want your share of the house to pass to the children. You can think about putting in a will trust in your will. So you can say, okay, I leave my share of the house to the surviving spouse, my surviving spouse. And after their death, I want my share of the house to pass to other beneficiaries, to my children and other relatives. That is a way of protecting half the value of the house. And you can only do that if you have a will in place. And likewise, some people are concerned about care fees. Too often, I have people who have come to see me to prepare their will. And we generally they'll say, okay, we want to leave everything to each other. But then they said, you know what? And I start talking about life interest wills, which means that it's a way of protecting half the value of the house against care fees. So the survivor can enjoy the house while they're alive, but if unfortunately the survivor has to go into care, the local authority can't touch half the value of the house. Many people have stories of relatives who have had to spend all their savings, sell their house to pay care fees. In your will, if it suits you, it's an opportunity to avoid at least protecting half the value of the house against care fees. And that's something you can do if you have a will. And remember, if you're with somebody for a long time and you get married, you no longer have a will. That will doesn't stand unless you put a specific something in the will, in the new will, to make sure it stands. So this week someone said, well, we've got a will, we don't need a new will. The will they did prior to marriage no longer stands. So it's worth reviewing your will as oftenest.
Yeah, I just wondered, is there services about that do wills for free?
It's National Free Will Network. As a firm, we have done free wills, provided people leave money to charity. At the moment, we've done lots, and we've fulfilled our quota. So yes, some charity, the National Free Will Network, they do it. But that only covers a basic will. So a lot of these nuances I've talked about will not be covered by a standard will. I have people who have got lots of money who come and do free wills, which is fine. That is fine. But it might not actually suit their needs. Right, so that's wills. I hope I'm going to move on.
My husband died recently, and his will, I did mine, and he did his 2000 and something. His will states that I'm the executor, and then if I die, my oldest daughter, then my son. And my will states the same. Now, is my will still valid?
Yes, yes. So what we do, we offer free will reviews. And if you came to me with your will, and I'm sorry to hear about your loss, I would say that you don't need to change it. We can review it. You know, maybe you want to appoint both your children equally to act as executors, I don't know. But if the will's fine, there's no need to change it. Okay? Right, so I'm going to talk about lasting powers of attorney. Yeah.
If you don't have a will, but you're married and you die, then is it automatically everything goes to your spouse?
No. Well, the first thing about not having a will and passing is that the whole process of dealing with your will takes much longer. That's big delays. Depending on how much you have in your sole name, it might mean that the survivor may get everything. But if it's over 322,000 in your sole name, which may be possible, and depending how you own your home, it will be divided between your spouse and the children. And once the intestacy rules kick in, you cannot determine how your children receive their share. It may be a share passes to someone who's got disabilities or is vulnerable, and you want to protect them. So it might not be sensible, because it might affect support they get elsewhere, that they receive that money directly. They can benefit from the money, as they should, but the money may be best to be put in a trust. So it's best to have a will. I mean, I've dealt with cases recently when husband and wife, the property, the husband had the business, the house was in his name. Unfortunately, he passed away, no will, and now having to piece everything together, and the wife is not entitled to everything.
Should this house, some single person with 3 children, that's it, the house, not much money, would it just, anyone's understood it just go to my children if I died?
Yes, without having got a will.
I haven't at the moment, I do plan to start finding.
Yeah.
But
Yes.
it's just passed to my children directly.
Yes. Right, so I'm going to talk about lasting powers of attorney. So a will and executors are just for after you've passed. A lasting power of attorney is to support you while you are alive. So there's 2 types. One which deals with money matters, and one which deals with health and welfare matters. So the money matter one could be from buying and selling a property, supporting you, set up a bank account, to talking to a utility company. If you haven't appointed someone you trust, that's the key thing, it's people you trust to assist you when you can't help yourself as you used to, then they don't have any legal right to support you, whether you're married or not. If you've got a joint account, then the other joint owner can access accounts and stuff like that. But if you've got assets in your sole name and you at some point are unable to manage your affairs for whatever reason, then nobody else legally can access that account. So people say, well, I'm married. No, and when people want to be difficult, they will be difficult. The banks will be difficult when they want to be difficult. Some people are worried. So the power of attorney gives someone the authority to deal with your affairs on your behalf. It doesn't mean as soon as you sign a power of attorney, they're going to take it off to the bank and start clearing your bank account. I know some people are a bit worried about that. Oh, I don't need it now. I'm fine. The problem with leaving it till later is that you don't know what the future holds. You don't know when you're going to be unwell, and you don't know when you're going to need it. So it's sensible to prepare a power of attorney while you're well.
Is it better to have a single power of attorney one person?
It's best to do, I mean, what I find, people say, oh, should I have both children down? The way the power of attorney can be set up is that you can set it up so it's joint and several. So if, like lots of families, I'm conscious I won't because I've got my daughter here, so I won't reference my children. But if you have one child who is more willing to sort of help or better with paperwork more than the other child, the person who's better with paperwork can go ahead and help and do more, be more proactive than the other. But you can have two down. If they don't work together, then maybe, well, it's best not to have two down then. Because those sort of things you can talk about. If you don't decide that yourself now, that decision might be taken away from you because they might have to apply to the court. And both of them are going to be arguing, I want to sort out mum's affairs, I know best. So it's an opportunity for you to say who's going to deal with the affairs. So the other power of attorney is to do with health and welfare matters. Some people say, well, look, I've got a power of attorney which deals with money matters. I don't need this other one, health and welfare one. But I've come across it quite recently, that it's sensible to do both. So health and welfare only kicks in. You only can use it they only can use it if you lose your capacity. And it could be from where you're going to live, what you eat, the sort of support you get from the authorities. At times, the social services may turn around and say to a loved one, I'm sorry, I'm not going to talk to you, I'm not going to listen to you, I'm not going to take your instructions, I'm sorry if this is a bit controversial, because you don't have power of attorney. And they can sometimes take away rights. You might be supporting your child might have been supporting you for years, but you're in a situation where they can't support you as they would want to. So how about preparing a power of attorney while you're well, so that if there comes a time if you lose your capacity, your child or the person you trust is able to support you. The power of attorney for health also deals with life-sustaining treatment. Ultimately, the doctors are going to act in your best interest. But by having a power of attorney, and which says you are happy for your attorney to consent or refuse life-sustaining treatment, you're giving them a bit of weight when decisions are being made about your health. You don't have to. Some people don't want their attorneys to be involved with any health matters, and you don't have to give them that right to refuse or consent to life-sustaining treatment. But it can be helpful. And if you don't have these documents, you have to make an application to court, or your family will have to make an application to court, and that can take a very long time. It's much more expensive. I have a case where, at the moment, unfortunately, Mum has lost capacity. The local authority say the son can't make any decisions. He wants to sell the house to pay for her care, and it's gone on for months, and we're still not at the end of it. So if you don't have something, if you don't make the decision, that decision's taken away from you, and somebody else will have to make the decision. And of course, lots of stress, I think, to your family. Oh, I should add, you can go online and do these things yourself. You can go online and do lasting powers of attorney yourself. unfortunately, you can, and people have done. If you make a small mistake, they will be chucked back at you. So I always recommend, or maybe you'll say I would, I recommend you get it done by a professional.
Why are they so expensive?
Because it's a proper legal document. It might seem, you know, you're entrusting, it's a proper document, so they might seem expensive, but I always think about, it's a bit like an insurance policy. Have it in place. If you don't have insurance in place, you go a day late renewing your insurance, you're worried about it, and then all of a sudden something happens and you haven't got it in place. With a power of attorney, if you see it that way, you've got it in place. If you don't have it in place and you need it, then you're going to have to pay the court every year a court fee. Your children or whoever are going to have to do reports every year. And the same with the will. You know, it causes, if you don't have a will, it causes lots of delay and stress. And also it might end up costing you, it's sort of, you know, you miss out on the tax planning. So that's all I'm going to say on lasting powers of attorney, unless anyone's got any questions.
If you haven't done the financial aspect of it, can you then separately do the care component?
Yes, so they're two separate documents, lasting power for property and financial affairs, and one for health and welfare matters. If you've done the old enduring power of attorney, some people may have done enduring powers of attorney, they are still valid. So you don't have to do a new document. So, but alongside your financial, it is sensible, I think it's sensible to do health and welfare.
And do you need to have that registered separately?
They are two separate documents registered. So you can delay registering your powers of attorney, but it takes so long to activate it. You're better off registering it, keep it with your solicitor, keeping it locked up, and it comes out as and when you need it. It's there ready for it to go.
If your executor is not able to manage the estate, will the solicitor take over in that case?
Yeah, so you can always, people come with their wills, and unfortunately lost somebody, they come and they ask us, you know, can you support us? Yes, solicitors can support. Sometimes the person just needs a friendly conversation. So, you know, most solicitors will talk to you, you know, for a while and work out whether or not probate is needed and whether you actually need our support. And then they will say how we can support you if you want our support.
Can I ask about do not resuscitate orders? So would it be a good idea to get that as part and parcel of the
They are separate documents, but there is a part in the lasting power of attorney which is like instructions and preferences, and you might want to refer to it, and you let your family know, or you let your attorneys know what your position is. I saw someone else with a hand up there. Hi.
I was just going to say as well, similar to that some people in conjunction with their lasting power of attorney put in advanced care planning
Yes.
form, because just because somebody's your son or daughter, they might not have a clue of your wishes.
Yeah.
They might have moved away 20, 30 years ago, and they might not know that you have maybe quite radical views on your end of life care, that you want to be remaining at home, you want to be in a hospice, you're actually taken to Australia.
Yes.
You know, they might not know by the virtue of their love relation what your specific end of life wishes are.
Yes, yes. I think it's good. I mean, Rebecca talked about having letter of wishes. Leave notes, I think more information you can leave behind in some sort of organised way is good.
With the lasting power of attorney and wills and all that sort of thing, obviously the less straightforward they are, the more you pay. Now, the fees you pay, is that go towards your reducing your liability for inheritance tax?
No. I mean, sometimes people say they're only when you come. No, it doesn't reduce it. I mean, you can prepare wills that will reduce your inheritance tax, but the cost of preparing it, you can't reduce it. It doesn't reduce it, unfortunately. Well, hopefully it's a small amount compared to the advice you're given, and you end up saving lots of tax.
Unfortunately for some people,
other and they return the power of attorney to their own member of family, about the will, member of family or partner in business. What do you say in it?
So some people give power of attorney to. Sorry, can you repeat your question? Sorry.
They give a permit power of attorney about the will to their own members of family.
Yeah.
Like father, brother, sister, mother, or some their own relatives, you know.
Yeah. So your attorney cannot change your will. Your attorney cannot contact me and say, I want the will. The attorney is entitled to see a copy of your will, unless, this is one of the provisions, say, a professional would say, is unless you specifically say you do not want your attorney to see your will. But the attorneys have no right. Sometimes we have attorneys saying we want to see that will, and then now the legislation's changed, we need to show them a copy. But they can't change, an attorney cannot change the will.
I can see it.
Yeah. Okay.
Thank you very much.
Yes. I
Thank
think
you
I'll.
very much. You gave us a lot of information.
Oh, pleasure, pleasure.